In another development, President Muhammadu Buhari has stepped into another controversy between the federal and state governments. It is over the payment of $418 million to consultants that handle the Paris Club refund. Buhari has directed the Ministry of Finance to ask the Debt Management Office to stay action until all the cases are exhausted. There has been pressure from the Nigerian Governors Forum to stop the payments described as suspicious. All former presidents have refused to approve the payment because of lack of evidence of work done.
Let's now bring in Barrister Frank Tietie, the Executive Director, Citizens Advocacy for Social and Economic Rights, to discuss these issues. Thank you so much for joining us.
Thank you, and always my pleasure.
Great to have you. Interesting times we are, but let's start with the latest development with the appeal courts today. Help us understand this, because you're the lawyer. The House of Assembly in Rivers State has since passed a law authorizing collection of the VAT. Same has been done in the Lagos State House of Assembly, and the governor, Babajide Sanwo-Olu, signed it today. So what exactly is the status quo here? What is the legal implication of that order by the appeal court?
You know, there must be a distinction between stay of execution and maintenance of status quo. I think what the Federal Inland Revenue did with regards to the judgment initially, when it made an application to the Federal High Court in Port Harcourt, was to stay the execution of a judgment. Clearly, our laws don't support that, because the judgment wasn't that directed anybody to do or not to do anything. It simply stated the status of the law in Nigeria. That is, the state governments are now empowered by that declaration. It simply stated the law that they can now collect VAT and other taxes, and the federal government is barred from collecting those taxes by the provision of the Constitution, and they left it there. So there was nothing to stop. But the distinction in this Court of Appeal order is that maintain status quo, which ought to have been the application they would have made at the Federal High Court. So they made it now. But unfortunately, again, the Court of Appeal can only make an order as to the maintenance of status quo. However, the application before it is also to stay execution of what? The stay execution of consequent actions that may flow from the judgment from the Federal High Court in Port Harcourt. Unfortunately, again, you cannot really make injunctions to stop completed acts. Right now, in Rivers State, we have a law that is in place that is validly enacted according to the provisions of the Constitution. The law is in place, and there is no order stopping that law. There is no order making that law a subject matter before the Court of Appeal. So, I mean, there's no order stopping that law before the Court of Appeal. Yeah. So, the status quo right now is that the Federal Inland Revenue and the Rivers State government are stopped from collecting taxes. However, there is a legal regime that enables taxpayers in in Rivers State, to pay taxes to the Rivers State government. That is the subsisting law of the Rivers State government.
Are we not mixing things up? I am not a lawyer. But from what I understand from the Court of Appeal, status quo would mean go back to where it was before, do not move. Why was it before that the federal government was collecting, or the FIRS rather, was collecting the VAT, which is value added tax? So what I would seem to understand from that Court of Appeals judgment, which is a higher court to the High Court in Rivers, is that they should go back to FIRS collecting taxes until the judgment is decided as to what eventually happens.
That is not the import. You know, the judgment of every court in Nigeria is presumed to be correct and must be obeyed immediately. That's the presumption even the Court of Appeal holds. Now, when it says maintain the status quo as at the moment of the application that was made today, that is, let parties do nothing, but let the situation remain the same. Do not do things that would truncate and defeat the courts from making a judgment that will no longer have any form of significance, that is by destroying the rest. So the status quo as we speak this moment is that there is a law in Rivers State that has gone unchallenged, But there is a judgment that is being challenged. So what is the import of that judgment? The import of the judgment is that there is a declaration that federal government, you can no longer collect these taxes, and that River State government, you can collect these taxes. So until we have another action directly challenging that law that River State has made to enable its taxpayers within its territory to pay tax to it, until that law is set aside, that law becomes is still operational. And don't forget too that there are third parties who have interest in these matters beyond the parties, beyond River State and the Federal Inland Revenue. There are parties in River State who prefer the taxpayers who want to pay taxes.
We'll keep you on pause there.
We'll go on a quick break. Interesting conversation, but we'll come back to broaden it beyond even these parties involved. Stay with us. Newsnight returns in just a moment.
All right, glad to have you back. You're still watching Newsnight, and we'll still have Frank Tietie, Executive Director of Citizens Advocacy for Social and Economic Rights. Interesting discussion that we have been having. I hope we're not getting confused or getting the public confused. What do you suppose, Frank, will be the next step of both the River State government and the Lagos State governments? I had here now that their laws are redundant, but from what you're saying, their laws are not redundant. But what will be their next step?
Certainly not. That question probably should be directed to the entire tax environment. What do you think the third parties, the taxpayers, who nobody is really paying attention to now, will do? So taxpayers in Lagos will prefer to pay taxes to the Lagos State government, and the same in River State. They also have a stake in this whole matter. They are able to, right now, they don't have any basis for which those two laws that have been enacted by both Lagos State and River State to be set aside. There is no basis for that. The Court of Appeal order of today did not in any way affect those two laws. What that order applies to is the judgment that emanated from the Federal High Court. And that judgment simply was about its declaration about the state of the law. And then with the attendant reliefs that were sought and all sort of declarations. So what the judgment is saying that at this moment, River State government and the Federal Inland Revenue do nothing anymore with regards to VAT collection. That's what it means.
Okay,
so on the process, yes.
So do nothing anymore.
Do nothing. Do nothing.
So Rivers and Lagos cannot collect VAT.
No, they cannot collect tax based on that judgment. But don't forget that there is a different authority here, and that is the power of the State House of Assembly to make law. That is being validly made according to the Constitution and assented to by the governor. And that's the state we have in Lagos State and River State. On the basis of that law, taxpayers in River State and Lagos State do not need to be confused. They now know they have a basis for paying their VAT to a certain authority, which is either the Lagos State government or the River State government in this case.
You know, you're right, because economists and economic analysts have spoken about the air of uncertainty that this brings to the table at the moment until we get clarifications. But are there any positives? And let me ask you, are we effectively seeing the judiciary coming to the rescue of Nigerians in achieving a proper federation in terms of fiscal policy, in terms of devolution of powers? Would you say this is perhaps something to celebrate in that terms?
Yes, because that is the very basis of the and function of the judiciary in our constitutional democracy. That is, there will always be conflicts between arms of government, between various agencies and other interests, and it's the responsibility of the judiciary to resolve them. But you see, law should not be uncertain. That's why we have a written constitution that is clear, written in plain English. And when it is written in such manner, you give a literal construction approach to it. That is, you see to just give it a literal meaning. And the meaning is that based on the exclusive list, the items in items 58 and 59, federal government, you cannot collect other taxes beyond this number of taxes that have been listed there: capital gains, incomes, and on profits. Simple. And then VAT and all of that, they come into a concurrent list that, to a large extent, actually make it a matter that only the states can legislate upon, because the very mention, when we talk about rules of interpretation, the very mention of capital gains, profits, and incomes in the Constitution excludes the federal government's authority in making laws with regards to VAT. Right now, we have a law regarding collection of VAT in Lagos and River State. The interesting thing again, which is very positive, which I fear, because which is very important for the court to determine what status quo means.
Yeah.
Because
All right.
we are envisaging a situation
All right.
where 36 states will apply to join this
All right.
Court of Appeal
All right,
matter.
Frank,
do
like
we
we
have
were
the time?
discussing, behind the scene, this is just starting.
Of course, yes.
Probably get to say. So we'll watch as the events play out. Thank you so much,
Thank you.
Frank Tietie, Executive Director, Citizens Advocacy for Social and Economic Rights there.